Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 234 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues, we provide advice and assistance to both employers and employees on all aspects of employment law. Our flagship service for employers is our HR Harbour membership service, where for a fixed monthly fee, you can become a member, which gets you various levels of service depending on what you subscribe to, either silver, gold or platinum. And we will provide you with the reassurance and understanding of all aspects of employment law, including any changes that might be taking place. We will also support you throughout the year and help you to be the best employer that you can be. If you would like a no obligation quote or to find out more information about the types of services that we can offer for you and your business, please don't hesitate to get in touch. You can email me directly. My email is alison@realemploymentlawadvice.co.uk. Now, as you may be aware, there have been a number of announcements recently in relation to Labour's plans for employment law. And on Thursday, the 10th of October, they announced the Employment Rights Bill. And so in this episode of the podcast, I'm going to give you a summary and the key information from the Employment Rights Bill. So without further ado, we'll get into this week's featured content. No doubt you have heard in the news or you've read online about the Employment Rights Bill. Lots of people are providing summaries and updates on exactly what it states and the potential implications for employers. And so what I wanted to do was to bring you my views on it in an easy to understand way and hopefully provide you with some reassurance. So I have spent some time going through and actually reading the 158 pages of the bill, and I've noted some of the key points for you. The bill is readily available online if you want to have a look at that, and I'll put a link in the show notes, as well as some of the guidance notes that go with it, and also the government's statement on what they're doing next in relation to this. But the first thing I would say in relation to these proposed changes is that you don't need to panic. Nothing is going to be happening anytime soon, so there's plenty of time to prepare and understand exactly what's going to happen. And most of the changes won't come into effect until 2026. And in particular, the unfair dismissal changes, so the change to the qualifying period for unfair dismissal, won't be until the autumn of 2026. There's going to be a lot of consultation on the bill during 2025, and the government will be looking at refining and concluding the terms of what the law will be, and of course then it has to go through the parliamentary process. So at the moment we have the bill in its current form, but there is the potential for that to change as it goes through various stages of consultation and then to be ratified and eventually put into law. The other thing to note that further details of the policies that are referred to in the bill and some of the regulations and codes of practice will be dealt with after the bill has royal assent. So there's lots of detail that will come in regulations and codes of practice that aren't necessarily set out in the legislation as it currently stands. So the first change that I wanted to talk to you about is something that's very timely, as I've been doing lots of training about sexual harassment with people and explaining how the original sexual harassment legislation that's just coming in specified that employers needed to take all reasonable steps to prevent the sexual harassment from happening, but was actually watered down as it went through the parliamentary process. So it took out all reasonable steps. So in my discussions, when I've been doing the training with people, we've been talking about this. And actually within the new Employment Rights Bill, they are now putting the all back in. So if this legislation passes through and comes into play, then the requirement on employers will be to take all reasonable steps to prevent sexual harassment, rather than, as it currently stands, from the 26th of October this year, to take reasonable steps to prevent sexual harassment. So that could be a potential change, and I'm not quite sure how they will differentiate between reasonable steps and all reasonable steps. That's yet to be seen. And of course, in relation to the preventative duty, I imagine there'll be lots of case law on it, interpreting what exactly reasonable steps is. And then of course, if the law changes, there'll be this additional point of all reasonable steps. So it's just a point to note there. The second thing in relation to sexual harassment is that disclosures relating to sexual harassment will now become a qualifying disclosure for the purposes of whistleblowing protection. So you may or may not know that under whistleblowing protection, various things are set out as being a qualifying disclosure that qualify for protection from whistleblowing detriment or dismissal, and it will be included within those as a disclosure relating to sexual harassment. And while we're on the subject of sexual harassment, it's important to note that under the Employment Rights Bill, there will now be a requirement on employers in relation to third-party harassment. So you may or may not know that previously employers could be liable for the harassment of third parties of their employees, and the law was changed. So there wasn't that legal requirement to deal with harassment of third parties under the law, and there wasn't a specific claim about it. But now, if this law goes through, then there will be this obligation on employers to deal with third-party harassment, and employers will be liable for the harassment of their employees by third parties. So another reason why it's important to, when you're looking at your sexual harassment risk assessments, to think about the risks of harassment from third parties in relation to sexual harassment, but also I would say you should start looking at what the risks are generally in relation to harassment of your employees by third parties such as consultants, other organisations you might work alongside, or customers, etc. Now, the third major thing that's happening under the Employment Rights Bill, and this is something that's quite interesting for us as employment lawyers, is that the qualifying period for unfair dismissal will be removed. And what this means is that from day one of employment, employees will have the right not to be unfairly dismissed, and this will be subject to a statutory probation period. So the details exactly of how that will work haven't yet been set out, nor has it been set out the length of time that that's going to be. But in their accompanying documentation that the government have published on the .gov website, it does say that they will consult on the length of the initial statutory probation period, and the government's preference is 9 months. So it is looking likely that employers will be able to fairly dismiss somebody within the first 9 months of their employment if they follow a minimum process for doing so, and thereafter employees will qualify for unfair dismissal if you don't have one of those 5 fair reasons for dismissing them and you haven't taken reasonable steps in the process. So this is quite a big deal in relation to increasing the rights for employees. Again, the detail of what the statutory probation period will look like is unknown, but it's likely that there will be some code of practice or prescription set out of how employers are going to deal with those probation periods. Now, as I said at the outset, this isn't coming in until autumn of 2026, so it's looking likely that we will have 2 years before the law changes. And what that means is that employees continue to require 2 years continuous service to claim unfair dismissal up until that point. And again, details about how any transition periods will work, but it's likely that from the start of the new legislation, it will start to apply to new employees. Now, one of the most publicised areas of the Employment Rights Bill, and the thing that's caused, I think, lots of dissatisfaction amongst employers, was the proposal to remove 0-hour contracts or to ban 0-hour contracts. Now, what the bill does do is provide further regulation in relation to how 0-hour contracts apply and are used. It doesn't ban them altogether, and I think it's important for people to note that employees who want to be on a 0-hour contract can continue to be on a 0-hour contract if they want to. I know lots of employers I've spoken to have said, we've got students who really like the flexibility, people who don't want to have to work, set hours and are quite happy to work as and when required and be flexible. So for those people that it works for, they don't have to take up the guaranteed hours part of this, and you can continue to have 0-hour contracts. So they're not being outlawed or banned altogether. But what it does mean is those workers who are on a 0-hour contract or a low guaranteed hours contract, so those people who may not have full-time regular hours, again, it's not really set out what low is going to be defined as in relation to this, so more detail will undoubtedly be set out later on. But in essence, it means that those people on 0 hours or low guaranteed hours will have the ability to move to guaranteed hour contracts, which actually reflect what they're really working. And there is going to be a 12 weeks reference period for this. And then if they work more hours after that and it becomes regular over time, then there'll be subsequent review periods, and then they would be entitled to be offered a guaranteed hours contract that reflects the hours that they're working. So what this really means in practice is something that I talk to lots of employers about, which is if you are regularly providing the same amount of hours of work to somebody, then it's not truly a 0-hour contract, and a 0-hour contract doesn't necessarily reflect that. So this is really providing some prescribed way in which employers have to deal with this, so that after that 12 weeks reference period, they will be required to provide guaranteed hours contracts. Now, what I would say about the bill as it currently stands is it's very prescriptive on how it's going to work in practice, and it sets out lots of information about review periods and how it's going to work, all of those sorts of things, and it's quite complex and complicated, and I would expect further detail about this to be set out in both the final bill and also codes of practice. And it does also set out that employees can make various complaints to employment tribunals if their employer doesn't follow the correct procedure, and they have the same amount of time to make their claim as current claims, which is 3 months, depending on when the employers failed to follow the relevant procedure set out by the bill. Now, in addition to the right to guaranteed hours, there are also additional rights and responsibilities set out for employers to provide reasonable notice of shifts and to provide reasonable notice of the cancellation or change to a shift. So those people who don't have guaranteed hours are now going to be entitled to have a period of notice which is set out and prescribed by law, and employers will have to adhere to that. And again, it seems quite complicated and complex as it's set out in the law, and a further detail no doubt will follow. But in essence, if employers fail to do what's required, then the employees will be able to make a complaint to the employment tribunal and be awarded compensation for their financial loss as a result of that failure. And then finally, employees will have the right to a payment for any cancelled, moved or curtailed shifts. So that's where they are out of pocket as a result of a change or cancellation to their shifts. Again, they'll have the opportunity to make a claim to the employment tribunal for that failure, and there may be further regulations set out about how that works in practice for employers in due course. So a number of additional protections and guarantees in place for those people who are on 0 or low hour contracts. And again, not banning 0-hour contracts altogether, rather providing employers offer a guaranteed number of hours under a contract if they've worked for a 12-week reference period. The next thing to note is there is additional protection in relation to pregnancy. So instead of the protections and measures being in place just for redundancy dismissals, it will apply to all dismissals during pregnancy and upon return to work. And again, further detail will be set out in relation to that in due course. Next up is the ending of the ability for employers to fire and rehire employees when they're looking to change their employment contracts. So as you may know, if you want to change the terms of somebody's employment contract, it has to either be set out within the terms of the contract that you can do that, or you have to seek the agreement of the employee to the change. Now, what often happens in situations where employees don't agree to the change to their employment contract, employers will then give them notice to terminate their employment and then offer to re-engage them on the new terms. Now, sometimes that can give rise to a claim for unfair dismissal, but in other cases, it can be very difficult to pursue, and employees are often left with no choice but to accept the new terms. Under the Employment Rights Bill, this will then be an automatic unfair dismissal. So if an employer dismisses an employee and the reason for that dismissal is that they were seeking to vary their employment contract and the employee didn't agree, it will be automatic unfair dismissal. And what this means then is that essentially employers will only be able to dismiss an employee where they want to change their contract terms in very limited circumstances. And again, this is set out within the terms of the bill, but in essence, if an employer is in significant financial difficulty and can demonstrate that, and they follow a full reasonable process to make the variation and are still unable to do so, then they may be able to successfully defend a claim for automatic unfair dismissal if an employee brings a claim. It's also important to note that there will be no qualifying period of employment in relation to this, so it will be automatic unfair dismissal from day one of employment if the reason for the termination is that the employee refused to accept a change to their employment contract. Now, the next key thing to note is in relation to flexible working. As again, the headlines said, many people were worried about the fact that Labour were planning to make flexible working the default, and many employers felt that they would have no choice but to accept employees' requests for flexible working, potentially to the detriment of the business. Well, the law actually goes far less than was expected in relation to this. So the Employment Rights Bill keeps the fact that employers can refuse on one of the 8 grounds. They remain very similar to the existing grounds, but in essence, employers can refuse a request for flexible working if they have one of those 8 grounds for doing so. The only real change is that employers now have to explain to the employee why it was reasonable for them to refuse that application. So currently, if an employee makes a request for flexible working, an employer need only say that they are refusing on one of those grounds. They don't actually have to go into any further detail. Now, employers will have to show that it was reasonable for them to refuse the application on that grounds and explain that to the employees. If an employee is unhappy with those grounds or the reasons, then they can make a complaint to the Employment Tribunal. And if the Employment Tribunal find that the employer doesn't have reasonable grounds for that refusal, then they would be entitled to compensation, but it still remains just at 8 weeks' pay. So not a huge amount of change in relation to that. The only difference really currently, as it's set out, is that employers will have to provide more detail about their reason and demonstrate that it was reasonable for them to refuse. Following on from Labour's pledge to make lots of employment rights available from employees from day one, they've removed the waiting period and lower earnings limit in relation to statutory sick pay, so employees will qualify for statutory sick pay from day one, and they will also be entitled to paternity and parental leave from day one of employment. Now, you may recall a couple of years ago, the right to parental bereavement leave was introduced so that employees who had lost a child were entitled to a statutory period of leave. So under the new bill, it will be bereavement leave for all in relation to other eligible bereavements. So it won't just be in the circumstances of losing a child. So it's basically prescribing a set of bereavement leave for 1 week in relation to other relatives, we assume, although it hasn't actually been set out who the relevant persons are that you would qualify for bereavement leave. That detail is no doubt to follow, but I would imagine it will follow some of the other kinds of carers leave requirements in relation to it being a relative or somebody that you care for or someone in the same household. But again, we don't know yet. So in essence, employees who suffer a bereavement in relevant circumstances will be entitled to 1 week's leave, and those employees who lose a child will still be entitled to have 2 weeks bereavement leave. Now again, many employers go much further than what the law states in this regard and would of course allow employees to have more time off in the circumstances of bereavement. But again, it's just important to note that this will be a change that you need to incorporate within your handbooks and policies and procedures once it comes into play. Next up is in relation to equality action. So there will be regulations that will set out that large employers, so those with over 250 employees, have to develop an equality action plan, which sets out the steps they're going to take in relation to gender equality, and they may also have to publish some prescribed information about that. So again, looking at making those larger employers more accountable for gender equality, and they would also have to set out how they're supporting employees through menopause. So a couple of additional obligations that will be in place for large employers. There is a change in relation to collective redundancies. So currently, employers have to collectively consult if they are planning 20 or more redundancies within a 90-day period at one establishment. And what's happening with the change is that reference to one establishment will be going, so it will cover the whole organisation. So employers, for example, who have a number of branches of a store around the country may only be making 1 or 2 redundancies at a single store, and therefore under the current law wouldn't be required to collectively consult. But if they are making more redundancies at other stores around the UK that come to a total of 20 or more, once the law changes, they would be required to collectively consult. The government are also intending to establish a Fair Work Agency, which will bring together lots of existing enforcement functions in relation to national minimum wage and statutory sick pay and the Employment Tribunal penalty scheme. And so they're looking at setting that up as a kind of body to oversee lots of this new employment legislation and employee rights. They're also introducing a whole host of trade union reforms. So in Part 4, Sections 45 to 71 of the Employment Rights Bill is a whole host of information about trade union reforms. So if you're interested in that particularly, that's where you go and have a read. But the main thing for employers to note generally is that they will be required to give workers a written statement that they have the right to join a trade union. And it said this needs to be given at the same time as their Section 1 term, so that's their employment particulars or employment contract, and potentially at other prescribed times. So in essence, the practical application of that would be that employers would need to set that out either in the employment contract to be certain that it's covered, or in a separate notice at the same time that they issue that employment contract. So that's the main proactive change for employers, and there are, as I say, a number of other changes in there in relation to trade union reforms. Some of the other points to note in relation to the proposed changes are that there's a public sector outsourcing protection of workers. There are provisions in there for the pay and conditions of school support staff, including establishing a school support staff negotiating body. There are also provisions for establishing an adult social care negotiating body. I think recognising that both those school support staff and those working in adult social care don't traditionally have access to a trade union, and therefore setting up these negotiating bodies in relation to their pay to provide more fairness across their pay and negotiating. There is also a substantial part of the bill, Part 5 of the bill, which sets out details of the Labour Market Enforcement Agency and strategy, and some things that aren't included in the bill but are set out in their document What Happens Next, and information to accompany this bill, are that the government are proposing to consult about moving towards a single status of worker. You may have listened to me talk on the podcast about the Taylor review that took place several years ago, specifically in relation to looking at the world of work generally, but understanding the different status of people and how people are working these days. And it looks as though they're planning on consulting to make that simpler for everybody involved. There is also the potential for enhanced protections for self-employed workers, as well as further trade union reforms and repeals. And they have said that they would be looking at taking forward the right to switch off through a statutory code of practice. Again, the right to switch off is something that's been widely talked about in the media, but isn't actually set out in the current bill. But again, they're looking at dealing with that through a code of practice, as well as developing menopause guidance for employers. So again, the current bill is fairly light in relation to any change for menopause, merely referring to an obligation on those larger employers to publish what they're doing, rather than any prescriptive measures or additional protection in relation to menopause. So that's quite a lot to cover. There is some additional information that the government have published about their longer term delivery of reforms and looking at some of the things that they will be doing after this initial employment rights bill. And I will cover those off in a future podcast because this current employment rights bill is fairly hefty. There's a lot to consider and lots of information to take in at this time. So this isn't the last time we'll be talking about the employment rights bill. We will, of course, be bringing you updates on it as the law develops and as consultation and information is published. As I said at the outset, nothing to rush and worry about immediately. This isn't looking to come in until at least 2026, possibly towards the back end of 2026, to be timed at the same time as the change to unfair dismissal. So for now, what you need to do is just be aware that this is an issue that will be coming up and you do need to think about in the future, that employees may have questions about it. You know, people hear things on the news but don't necessarily know the details. So, you know, reassuring employees what will happen when the law changes and how you will notify them. If you have any questions in relation to the Employment Rights Bill or anything else employment related, then please don't hesitate to get in touch. I'll be very happy to chat with you about it. And if you would like to hear more about our HR Harbour service, then please do get in touch. My email is alison@realemploymentlawadvice.co.uk. Thank you so much for listening. I hope that you have a fantastic 2 weeks, and I'll be back in a fortnight's time with more employment law and HR updates for you. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.